Hey friends, welcome to my YouTube channel. So today we're going to talk about revocation of gift under Transfer of Property Act 1882. So bear with me guys. We are going to discuss about that. Thank you. So gifts are a common way of transferring property between individuals. A gift is a transfer of property without any consideration, which means that it is given without any expectation of receiving something in return. However, sometimes it becomes necessary to revoke a gift. The Transfer of Property Act 1882 provides for the revocation of gift in certain circumstances. So first we will understand what is a gift. Before discussing the revocation of gifts, it is important to understand what a gift is. According to Section 122 of the Transfer of Property Act 1882, a gift is the transfer of certain existing movable or immovable property made voluntary and without consideration by one person called the donor to another called the donee, the accepted by or behalf of the donee. So revocation of gifts. Once a gift is made, the property becomes the absolute property of the donee, and the donor cannot revoke it unless there is a legal provision that allows for it. Section 126 of the Transfer of Property Act 1882 provides for the revocation of gifts in certain circumstances. The circumstances are as follows. So, on the failure of the condition attached to the gift, if a gift is made subject to a condition and the condition is not fulfilled, the donor can revoke the gift. However, the condition must be a condition precedent, meaning that it must be a condition that must be fulfilled before the gift becomes operative. If the condition is a condition subsequent, meaning that is a condition that must be fulfilled after the gift becomes operative, then the gift cannot be revoked. So on the non-performance of the obligation attached to the gift, if a gift is made subject to an obligation and the donee fails to perform the obligation, the donor can revoke the gift. However, the obligation must be an obligation imposed by the donor and not an obligation imposed by law. So on the donee's refusal to accept the gift, if the donor refuses to accept the gift, the donor can revoke the gift. So on the donee's conduct that is inconsistent with the condition of the gift, if the donee's conduct is inconsistent with the conditions of the gift, the donor can revoke the gift. For example, if the donor gives a property to the donee on the condition that the donee will not sell it and the donee sell it, then the donor can revoke the gift. So on the donee's attempt to kill the donor, if the donee attempts to kill the donor can revoke the gift. So now we will understand procedure for revocation of gift. So if the donor wants to revoke a gift, he or she must give notice of revocation to the donee. The notice must be in writing and it must be served on the donee. If the gift is immovable property, the notice must be registered. The notice must also state the grounds on which the gift is being revoked. So in conclusion, we can say gifts are a common way of transferring property, but sometimes it becomes necessary to revoke a gift. The Transfer of Property Act 1882 provides for the revocation of gifts in certain circumstances. The donor must follow the procedure for revocation and the grounds for revocation must be valid according to the law. If you are considering revoking a gift, it is important to consult a lawyer who can guide you through the complete process. So friends, if you like this video, please do subscribe if you have not subscribed yet, and do like this video and do share as much as you can with your friends or family members with, this video. Thank you.